What if I told you that without the right plan, your life savings, your home, and even the simple decisions about your own healthcare could be tied up in a legal maze for years? Or worse, distributed in ways you never intended? Imagine the stress, the heartache, and the financial burden left on your loved ones during an already difficult time. This isn't just about money, it's about control, peace of mind, and ensuring your legacy is exactly what you envision. Too many families discover these harsh realities only when it's truly an emergency. Welcome. Today, we're tackling a topic that many of us tend to put off, but one that is absolutely crucial for anyone over 55, estate planning. You've worked hard your entire life to build what you have, and you deserve to know that your wishes will be honored and your family will be protected. This isn't just for the ultra-wealthy. It's for every American who cares about their future and the well-being of their loved ones. By staying with me through this entire video, you're going to uncover simple yet powerful strategies to safeguard your family and your assets, ensuring your legacy is secure. Let's start with the very foundation of any good estate plan: why it's so important in the first place. Many people mistakenly believe that estate planning is only about what happens after you pass away, and only if you have millions in assets. That couldn't be further from the truth. A comprehensive estate plan is a roadmap for your entire future, including what happens if you become unable to make decisions for yourself due to illness or incapacity. Without this roadmap, the state steps in, and their decisions might not align with what you would have wanted. This lack of planning often leads to lengthy, expensive, and emotionally draining court processes known as probate, which can devour a significant portion of your estate and cause immense stress for your family. One of the most recognized components of an estate plan is a will, or more formally, a last will and testament. You might think, I already have a will, so I'm covered. But is it up to date? And do you understand its limitations? A will is a vital document that clearly states how you want your assets distributed, and if you have minor children, who you designate as their guardian. However, a common misconception is that a will avoids probate. It doesn't. In fact, a will must go through probate court to be legally validated and executed. This process can be public, time-consuming, and expensive. Moreover, if you only have a will, assets without a designated beneficiary will be subject to probate. Forgetting to update your will after major life events like marriage, divorce, births, or deaths is another significant pitfall, potentially rendering your carefully laid plans obsolete. Now, let's talk about a powerful tool that often gets overlooked or misunderstood, but can be a game changer for asset protection and avoiding probate: the trust. Unlike a will, assets held within a properly funded living trust generally bypass the probate court entirely, saving your family time, money, and privacy. A living trust allows you to maintain complete control over your assets during your lifetime. You can amend or revoke it as your circumstances change. Upon your passing, the assets are distributed to your beneficiaries according to your precise instructions, often much faster and more efficiently than through a will. There are various types of trusts, each serving different purposes, from protecting assets from creditors to providing for special needs beneficiaries. Understanding if a trust is right for your situation can be one of the most important discussions you have, beyond what happens after you pass. A critical aspect of estate planning addresses what happens if you become incapacitated and unable to manage your own affairs. This is where powers of attorney come into play. There are typically two main types: a durable power of attorney for financial matters and a durable power of attorney for health care. A durable financial power of attorney designates someone you trust to handle your finances, paying bills, managing investments, and making financial decisions on your behalf, should you become unable to do so. Without this document, your family might have to go to court to establish a guardianship or conservatorship, a process that can be intrusive, costly, and may result in someone you wouldn't have chosen making your financial decisions. Equally important are your healthcare directives, sometimes called an advance directive or living will, along with a durable power of attorney for healthcare. These documents allow you to make your medical wishes known regarding life-sustaining treatment and appoint a trusted individual to make healthcare decisions for you if you cannot communicate them yourself. This ensures your values and preferences are honored during a difficult time, easing the burden on your family, who might otherwise face agonizing decisions without clear guidance. Imagine the relief of knowing you've taken control of these intensely personal choices, giving your family clarity and peace of mind. Another powerful yet frequently neglected aspect of estate planning involves beneficiary designations. For many of your assets, such as life insurance policies, retirement accounts like 401ks and IRAs, and even bank accounts, the beneficiary form you fill out at the financial institution often overrides anything stated in your will. This means if your will says your children should inherit your IRA, but you still have an ex-spouse listed as the beneficiary on the account, that ex-spouse will receive the funds. This is a crucial mistake that can derail your intentions and cause significant unintended consequences. Regularly reviewing and updating these beneficiary designations is simple, free, and incredibly effective in ensuring your assets go exactly where you intend. Don't let an outdated form undo years of careful planning. Life is dynamic, and your estate plan shouldn't be a one-time event. It needs to evolve with you. Major life changes like a marriage, divorce, the birth of a grandchild, a significant change in financial circumstances, or even changes in tax laws should all trigger a review of your estate plan. Many people create a will or trust and then forget about it for decades. This can be a huge mistake. An outdated plan might not reflect your current wishes, could be legally invalid, or might not be the most tax-efficient strategy given current laws. Think of your estate plan as a living document, requiring periodic checkups, just like your own health. A review every 3 to 5 years, or after any significant life event, is a good rule of thumb to keep your plan robust and relevant. Now let's talk about some of the most common and often devastating mistakes people make. The first, as I mentioned, is simply not having a plan at all. The second is assuming your family knows what you want. While you might have had conversations without legally binding documents, your wishes are just suggestions. Another mistake is using generic online templates without professional guidance. While these might seem cost-effective up front, small errors or omissions can lead to huge legal headaches and expenses for your family down the line. Estate planning isn't a do-it-yourself project for most people. Finally, failing to fund your trust if you have one is a common and critical error. A trust is only effective if your assets are actually transferred into it. If your assets remain outside the trust, they will still go through probate. The cost of delay, or procrastination when it comes to estate planning can be astronomical, far outweighing the cost of creating a solid plan today. Think about it. A well-crafted estate plan can save your family tens of thousands of dollars in probate fees, legal costs, and potentially unnecessary taxes. It saves them countless hours of navigating complex legal processes. More importantly, it saves them from emotional anguish and family disputes during an already tender time. Waiting until a health crisis hits or until it's too late leaves your family scrambling, making difficult decisions under pressure, and potentially facing outcomes you would have hated. The peace of mind you gain, knowing everything is in order, is truly priceless. Take control now, before circumstances take control for you. So, what have we learned today? Estate planning is not just about death and taxes. It's about living confidently, knowing your future, your assets, and your loved ones are protected, regardless of what life brings. Remember, a comprehensive plan goes beyond just a will to include trusts, powers of attorney, and healthcare directives. It's crucial to keep beneficiary designations updated and to review your plan regularly. The biggest takeaway is this: you have the power to protect your legacy and spare your family immense hardship. Don't wait for an emergency. Act now to secure your peace of mind and ensure your wishes are honored. If this information has been helpful, please give this video a thumbs up. It helps us reach more people who need this vital advice. Don't forget to subscribe to our channel for more practical financial tips tailored for your golden years. And we'd love to hear from you. Have you started your estate planning? What questions do you have? Share your thoughts and experiences in the comments below. Your input could help others in our community. Thank you for watching.